without written authorization. I guess my question is, written authorization, is that pictures also? Because I'm just asking, I agree that it's a civil penalty. I'm just not sure that that's the right citation for it. And maybe it is, I'm just asking. It seems like if I swipe somebody's pictures, that's a big no-no in our MLS. So is this an MLS issue, or is this, I'm just asking for clarification. I think there's a complaint there, yes, I'm not arguing with that. And I'm not arguing over $500. I'm just not sure if that statement says property shall not be advertised without written consent. Is that the right statute that we should be referring to?
My question would be, it was a new listing, so did the listing expire? No. That's the question. So, like you're saying, it seems like it's more of a swiping somebody's pictures than listing without written permission.
Right.
And that was my concern as well, that the rule could be read as that it has to be a current listing. And so I did discuss this with Ms. Matlock, and we both we had differing opinions. And so I want to stay consistent with what the commission has done in the past. And it's my understanding that was to issue a civil penalty. But I certainly am welcome to learn and find out that that's not the standard and do it differently.
So the rule references that we are not to advertise property listed by another without written authorization from the listing agent or broker. And so when we talk about that, we would go back to the definition of advertising, which would be provided, if we have our red or green book, and at the top of 81. And so anything that would normally be included in an advertisement, you would need to get the other individual's permission to advertise that. So advertising states, all advertising, regardless of its nature and the medium in which it appears, which promotes either a licensee or the sale or lease of real property, shall conform to the requirements of this rule. The term advertising for the purposes of this rule, in addition to traditional print, radio, or television advertising, also includes but is not limited to. And then it starts to give examples such as signs, flyers, letterheads, email signatures, websites, social media communications, video or audio recordings transmitted through internet or broadcast streaming. And then the things that don't include, in here we stated it was advertising because it is promoting either a licensee or the sale or lease of a real property. And so that's why we were thinking that this would be a violation of the rules, because there wasn't specific permission here. And I think if you were at if you remember, we went to the outreach at CWT? Yes. And we made waves with this part because people didn't know that they had to get written permission to do the advertisement of somebody else's property or advertising. And I think based upon that, that's what we were thinking in the process here.
So, for clarification.
Yes.
Property listed by another, does that mean anytime previously or a current listing? Because my question is it currently listed by that person, so they don't need written authorization to advertise it because it's not listed by this person. It was previously listed by this person.
I think the distinction is not that the two listings, one expired and one is currently in place. It's the pulling of the photos from the earlier listing,
right?
And then using a current listing.
Right. Exactly. We were like, what is the form of plagiarism of
I agree
of a listing?
That it needs
right.
to have a
penalty. It wasn't the person didn't take those pictures. They literally yanked my understanding was they yanked the listing from the other person and like copy and pasted it and used it again. And so that's what we were saying. It was the advertising the property listed by another. It doesn't say when, if it has to be current or previous, but it was either promoting the sale or lease of another property.
So does the record tell us who owns the photos? Is it the complainant or is it the seller, the property owner who is selling?
That wasn't exactly.
In your mind, does that make a distinction? Like if the seller, the owner of the property, who's the seller, owns the photos, they can then tacitly give permission by signing the listing agreement? Yes?
I don't think here in this case it would specifically matter, because my understanding is that
it sounds like
we would need to have, it states written authorization from the listing agent or listing broker. And so this rule used to state that we needed permission from the owner, but that's not what it states anymore. Mm-hmm. And we didn't have permission from the listing agent or broker in this case.
And it implies to me that we're talking about something in an MLS.
Right.
It doesn't say that here, but it's implied, or maybe I just am reading that in there. It looks like, from what I read, that I listed it, used some photos that I had made, and then Jeff goes and relisted when my listing expires and takes my pictures from the MLS. Is that what happened?
Question. Did they provide like the old listing and the new listing so you could look and see what was actually changed? Because the way I read it is the only thing they changed was the picture order, and not, they didn't change the layout, the colors, all the rest of the advertising. The what now?
The order would not have anything to do with it. If I take a picture and put it in there, and then you use the same pictures and you choose bedroom 3 instead of bedroom 1, and it's placed just like on this.
Correct. Well, to me, it says it's talking about swapping pictures and the advertising.
The question is, do we have any control over the picture? All it is I paid a photographer to go out there and take pictures. I used it for 3 months. It expired. The other went and relisted it, used my pictures. The photographer on the pictures, drawing pictures, room pictures. We have a right. Industry-wise, usually call the other agent and get professional courtesy. Mm-hmm. And typically they're like, yeah, we'll split them, you pay half back and whatever. But the question is, it's all about the pictures. It's not about illegal advertising.
In this case, the complaint, and unfortunately, to answer your question first, the complainant did not provide a copy of their listing. But in this case, I didn't feel like it mattered, because the respondent and the respondent's principal broker all agreed that that's what he did. That's what they did. That the listing was the same, except for the order of the pictures as you go through the ad.
Right. So Commissioner Beckley, it's everything. Like the words, like my understanding would be. Right. We're not saying it's copyrighted necessarily, but we're just saying like it's not just pictures. We're talking about like everything that was provided. So like every. Mm-hmm.
So civil penalties for what? Like what do we want to call it? $500 civil penalties for?
That was my original question.
What?
Well,
No, so the $500 civil penalty would.
Well,
It would be for the violation of the rule citation that we provided.
1260-2.
Unless you disagree with something else. Like if you don't think that's the appropriate violation.
I think when you read the rules completely versus just what was here, I have a better understanding.
Right. So I think the rule, and then going back, you have to take the context of what the definition of advertising means to get the full picture of what the rule means. But that's just, again, a recommendation you're open to.
Was when the photos were taken and used by the respondent. did the complainant still have an active listing agreement with that property?
No.
Okay. And based on that, then, this respondent, while guilty of poor judgment, I don't feel is guilty of that statute because it was not listed by another licensee.
That was my question. Does it mean
So-
previously listed, like,
No. Yeah, so I'm just,
before? I don't think
let's,
so. I
let's,
think it means currently listed. I think that
right.
like that statute means currently listed, even though it implies that it's currently listed or
yeah, I'm gonna sum it up here. And I would like to find them some, but I don't see how we can. But a letter of warning needs to go out. When this statute is read and taught in the core course, and it's specifying a specific thing not to do, and it's not in the same conversation as photos. Although photos and and that's kind of like a different part of the room, if you know what I'm saying. But the respondent ought to have called the complainant, gotten written permission or an email to say, yeah, you can use the photos, and they would have avoided this. And they realized they should have done that. So I think I would move to make a letter of warning to the respondent and the broker.
Yeah, is that a motion, Commissioner Ferris?
I move to make a letter of warning to the respondent.
Is there a second? I have a motion by Mr. Ferris to offer a letter of warning for case instead of the civil penalty on case number 20, seconded by Commissioner Begley.
Yeah, I have a question. What's the letter of warning? Hey, what's warning for?
Are we warning for the statute and the rule, reasonable skill and care?
We're not just signed for reasonable skill and care, even if it's got that statute.
We can.
I feel like that's a broad, like, this is reasonable skill and care violation. It's just,
Chairman Grease would say, well, you can find whatever you want. You're the commission.
These are just recommendations.
I think the respondent responded, apologized. They're probably embarrassed by the complaint as much as anything. I'm speculating here, but the letter of warning should say something to the nature of reasonable skill and care within the industry or within your college. I don't know.
Does that letter go to the broker and to because the broker is supposed to be responsible for what?
Yeah, I think to the broker
or the advertisement.
Yeah.
So I'm concerned that this agent did this without the broker knowing about it. So the broker should have been paying attention.
Well, to the broker's defense, you just don't know sometimes when things happen like this.
I agree.
But I would say it's a learning experience that the broker and their office can use, and perhaps others to know. And that's why I pulled number 20, is just to say, hello, you can't do that. But, yeah.
So we do have a motion. Is there any substitute motions or?
Substitute motion and saying $500 fine.
For $500 civil penalty for?
Sorry, civil penalty, yeah. So I think we're saying the same thing. It's a violation of reasonable skill and care, but it was deliberate, where I think a $500 civil penalty would make more sense than just a letter of warning.
So we have a
Substitute motion, should we just vote on that?
Oh, what do you want to do?
Let's just vote on the utensils.
Okay. So to restate the motion is to modify the council's recommendation to a letter of warning discussing reasonable skill and care on case number 20. Is there any further questions or discussion? Hearing none. All those in favor say aye. All those opposed?
No.
Motion passes on a 5-3 vote. All right, moving on. Case number 25 was mine. The only thing I wanted to know is that you cite the history of, there was a letter of warning issued to the respondent. I just wanted to see if you had any information about what that letter of warning regarding.
I do not.
You do not. Okay. I do not have an alternate suggestion for council's recommendation. I just wanted to know what the letter of warning was. But if you don't have that information, I will open the floor for a motion.
Yeah, we'll see if we can't find that.
Thank you. Number 25. There was one in the history. I just wanted to know what that letter of warning stated.
And I appreciate the question because that's good reference for future meetings. We need to make a note of that information.
Correct. And I would feel better about the recommendation. Well, I wanted more about the subject matter. I just wanted to know what it was, so I understood this respondent's history. You want us to move along? Okay. It's new, so I won't get blown away. Yeah, I'll be sitting right next to you, that's right.
Wasn't there another case this month, similar, where there was a question about how a contract was broken, and then the client actually communicated that they weren't coached?
That's on a represent, yes, sir.
Staples contract, okay.
I make a motion to accept the council's recommendation. Second.
I have a motion by Commissioner Gwynn to accept council's recommendation, seconded by Commissioner Bagley. Any further questions or discussion? Hearing none. All those in favor say aye. Aye. Any opposed? Hearing none, that motion carries 8-0. Case.
I'm not sure there's any way to what Jeff is doing to follow that, but I mean, you know, one of Chairman Green say, if this is repeated, you know, it turns into just the cost of doing business, so we do need to watch out for stuff like that.
Okay. So case number 28, I'm sorry, I was just reading my notes there for a second. I pulled case number 28. Council's recommendation was to do a $500 civil penalty. And on my notes here, I guess that's the question. How does reviews on social media, true or not, violate 1260.03.12.7? The title of the section is advertising, which governs their firm, the principal broker, and the affiliates of that broker. And I said activity might be unethical and should be reviewed by their association rather than this board. So I'm just kind of understand the fact set as to how you landed on that citation.
How I landed on it was this respondent made a claim that the complainant committed a criminal act. Mm-hmm. And there's no proof of that. The one complaint that was made to the Better Business Bureau has been resolved in the complainant's favor. This is pretty harsh and I would say disgusting language for one professional to make against another with no proof and there's not been, to my knowledge, a criminal complaint taken out or a report filed with the local law enforcement. It seemed to me to be beyond the pale, and so I went back to We had a case last month where the commission voted, or in June, where the commission voted to move forward with a civil penalty against a realtor who had posted a review under another realtor's, I think it was the Zillow page, stating that this realtor doesn't know the area and they're bad, and you won't be provided good service if you use this realtor, and that was found to be misleading, and the respondent agreed that they shouldn't have done that. So, social media is a tricky thing, and again, I just think this language in particular about this other realtor committing a criminal act. I mean, that's pretty blunt. Was inappropriate under that rule.
Okay. So because of the egregious nature
Yes.
of the respondent's comments, that's how you got there. Okay.
Yes, sir.
Is there a motion to accept council's recommendation? Motion by Commissioner Torbett to accept council's recommendation, seconded by Commissioner Smith, that we accept council's recommendation of a $500 civil penalty. All those in favor, say aye. Aye. Any opposed? Hearing none, motion carries 8-0. Commissioner Ferris, you had number 31.
Thank you. Yeah, I pulled 31 if only just to give this some air and light in a public meeting and to go out for a reminder across the state for licensees and citizens just to be wary of timeshares, be diligent with your interest in timeshares. I'm going to make a motion to accept the council's recommendation, but we've had timeshares come up throughout the past couple of years, and there's just these citizens need to know what they're signing, understand that there are some risks with timeshares, understand there's a lot of opportunity with timeshares. I'm not saying don't do a timeshare, but know what you're signing, and perhaps as licensee holders in the state, it's a good opportunity to be proactive, engage your clients, your people, and educate them about this. And that's the only reason I brought it up instead of putting it in the consent agenda to just be gone forever. And the tone of the respondent sounds like, the way I read it, noted that the recession period is long since passed, and it kind of is that blasé, hey, too bad, they signed. And that's kind of the vibe that I think the timeshare industry ought to seek to correct, instead of too bad, let's see how we can make timeshares better in Tennessee. So make a motion to accept, council's recommendation for item number 31.
Second. I have a question. What is the rescission period for timeshares? 48 hours?
No.
Just a little bit. 10 days.
10 days, but it was 5. Yeah. I think
Was it 10 days if you've seen the unit, 14 if not?
yeah. But it wasn't like that years ago. I hope the real estate commission was involved in making that decision.
And I think they've also been required to make the rescission period and the rules for rescission more conspicuous and not buried in the contract somewhere. Bold and conspicuous. Yes, so, but that might have applied to when this complainant signed their original contract. It is new. All right, so I have a motion to accept council's recommendation from Commissioner Ferris, seconded by Commissioner Torbett. Any further questions or discussion? Hearing none. All those in favor of the motion vote aye. Any opposed? Hearing none, that motion carries 8-0. I also pulled 36, but Commissioner Ferris, I'll let you speak first on number 36.
Yeah, thank you, Jeff. I'm looking at this, and I would make a motion here shortly to accept council's recommendation, but again, just a note to licensee holders is to get representation in writing always. It's in our core course. It's a bedrock principle with regards to getting your, operating with your license, and that just needs to be emphasized. So that's all I've got.
Well, because of the previous history of this respondent, the consent order for improper, fraudulent, and dishonest dealing, my recommendation would be to modify council's recommendation to include education, so the civil penalty plus education on a core course to complete it within 120 days, and does not count towards their CE. If somebody will make that motion.
I'll make that motion.
To leave the fine.
Can't we up it to 1,000?
It can. Sure. Anybody wishing to speak? So again, the motion I would entertain would be to accept council's or I'm not opposed to council's recommendation, but I wanted to add a core course to complete in 120 days and not count towards their CE. But I would defer to the rest of the commission if they want to modify the fine.
You want to modify the fine?
So I have a motion from Commissioner Smith to accept council's recommendation with the addition of the core course that could be completed in 120 days and does not count toward CE requirements. Is there a second? I did say 120. 6 months, 180? 6 months is 180. Okay. So to restate the motion, bad at math today. The motion is for a $500 civil penalty plus a core course to be completed within 6 months or 120 days, and it does not count toward their CE. 180 days. It does not count towards their continuing education requirements. And I heard a second from Commissioner Tucker. Any further discussion or questions? Hearing none. All those in favor of the motion say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Number 37, Commissioner Ferris.
Yeah, this one on 37 caught my attention for the number of items in the history of the respondent. And then the matter at hand regarding earnest money, I just would like some more info if the council could provide that, please. The respondent stated they did not represent complainant in the civil matter and only conveyed the message that the case had been filed. They deny they caused a delay in the court proceedings. I just would like a little more information as to how that relates to the earnest money, and if the respondent did not timely account for the earnest money, and given their history, then perhaps a fine is in order.
So in this situation, it did not appear as though there was an issue with getting the earnest money to the seller or the buyer. It was just a dispute between the two of the parties. What I understood from the complaints and all the documents that I read is that after there was a dispute, they promptly took it to civil court, and they had an attorney in civil court deal with it. The complainant called the respondent and said, like, hey, did the case get filed? They said yes, and that's really much like the entire involvement they had. They didn't go to civil court for it. They didn't represent them or anything like that. It was just that conversation, and the complainant didn't seem happy about that. I guess there's a time difference from like actually starting the civil proceeding, but I just didn't believe that the respondent would have control over.
Okay, but the complainant was made whole here and didn't.
I'm not sure if the.
But it's still in litigation.
Yeah.
Okay. Well, I feel like the respondent ought to at least get a letter of warning. Just given they've got some history here, but I'm open to discussion. I'm also open to just dismiss.
Did they get their earnest money, or that's what's in civil court? They still don't have their earnest money?
That's still in civil court, to my knowledge. And so a dispute between the two parties.
Is the respondent otherwise a part of the party to the transaction at all?
They represented, I want to say the seller.
Commissioners? Any motions?
I'll make a motion to accept.
Second.
I have a motion to accept council's recommendation from Commissioner Bagley, seconded by Commissioner Ferris on case number 37. Any further discussion or questions? Hearing none, all those in favor, say aye. Aye. Any opposed? Hearing none, the motion carries unanimously. Case number 52, DJ, you and I pulled this one too. Go ahead.
Pulling up my notes here for 52. So this is, what is at issue here is the advertising of a home that was built for a 4-bedroom, 3-bath house. And after the contract was signed, the complainant's agent noticed that the septic system was only approved for a 3-bedroom home. I think that that the respondent ought to be fined $1,000 as opposed to $500, based on what looks to be knowledge of the septic records and then advertising the home incorrectly.
Is that a motion?
That is my motion.
I have a motion by Commissioner Ferris to increase the civil penalty to $1,000, seconded by Commissioner Moffett. Any further discussion or questions? Hearing none. All those in favor of the motion say aye.
Aye.
All those opposed?
No.
I have a vote of 7 to 1. The motion carries. Case number 63 is, and me also. Mr. Smith?
Okay. I had a question. Was this one of those listings that goes for years and years and years?
Oh, you mean like a...
Yeah, you gotta
if
do
you decide
this.
to sell in 40 years, you have to use
You
our
have to
firm?
do me. Yeah.
That is the kind of system it is, yes.
Is that what, that's
Yeah,
what
it's
this
like you
complaint,
just- yeah,
that's
you
what
decide
this
to sell
is?
And then future, it's not currently for sale, you'll use us exclusively, and then you give like some very difficult things to kind of get out of it. It's like you like
Yeah.
get out within like 5 days.
Or I get a piece of the
Do this.
commission that covers
Correct,
it.
yeah,
Okay.
it was a very,
Yeah, I pulled this one. Besides dismiss and flag, I thought we would refer to the Attorney General. That would be my thought on it. But commissioners, any discussion? Mhm.
I thought we had a discussion on this, and isn't there some kind of legislation working toward this? Am I misreading this somewhere?
So legislation was passed related to exclusive right to list listings, and the legislation is related to. It went into effect July 1st of 2023. So, but it does not apply to retroactive contracts. And at this time, the legislation doesn't give this commission exact disciplinary powers. So what it provides for individuals that are impacted is if their exclusive right to list, the listing agreements are recorded, it provides them an avenue to go through Chancery Court and for that listing agreement to be essentially rescinded. And there are certain remedies that are available to them in that pathway. However, we're still working to find other avenues to address and remedy individuals that are impacted through this situation. So it is not something that is off of our radar. Just that is the current state of legislation as it stands.
Any further questions, discussion? Is there a motion? Again, council's recommendation was to dismiss and flag. I have a motion to accept council's recommendation by Commissioner Smith, seconded by Commissioner Torvett, that we accept council's recommendation on case number 63. Any further discussion or comments? Hearing none. All those in favor say aye. Aye. All those opposed? Hearing none. That motion carries unanimously. And now, for case number 64, you wanted us to discuss.
yes.
Council, What do you want us to know?
Okay, so in this situation, the respondent is accused of taking a $6,200 commission check and putting it in a personal account. The reason I wanted to discuss is because there seems to be a lot missing from the complainant on their side. They provided some emails, but the emails just essentially consisted of who saw the check last, and it was like, oh, the respondent did, and I didn't see anything that indicated that it went to their personal account or where the money went. But I did want to assess a minimum of $1,000 civil penalty for not responding because the respondent did not address any of the accusations in this. The complainant did say that they're doing criminal charges in the matter, so I didn't know if it would be best for litigation, but since it's an issue of theft, if we wanted to suspend their license or revoke it, it just seemed like there's a lot of issues and wanted the commission to discuss it to see how you wanted to proceed on this one.
So is there a criminal investigation?
Yes, but, well, we say indicated in it.
They indicated it, okay.
The complainant said they were going to go for it. They were out the $6,200 there to pay to the title company.
So the title company was the harmed party here at $6,200?
Yes. $1,000 civil penalty and legal monitoring or whatever it's called, and then wait and see what happens. Litigation monitoring? Yeah. I guess the concern is that their license is still active, and if they're being accused of this, I don't want them continuing to go out and additional money or...
Accused is different than being convicted.
That's correct, yeah.
So can I make a motion that we accept council's recommendation for the $1,000 civil penalty and also have litigation monitoring in case there's a criminal charge?
Well, there's...
Criminal charges that automatically come before us again? Or is the license automatically...
Well, they have 60 days to notify us of their criminal conviction, otherwise it is automatically revoked, right? Depending on what it is, a felony?
If it's related to theft or crimes of dishonesty, then they have 60 days to let us know if a guilty plea or a conviction. If they don't, their license is automatically revoked.
Okay.
So they're enumerated offenses that are found in C12.
So the statute that I'm referencing is 6213-312F. So it states that if an individual is convicted or pleads guilty to certain enumerated offenses, they have 60 days to notify the commission of the guilty plea or conviction, or if they're not, that their license shall be automatically revoked. And the enumerated offenses are found in 6213B12. And so those are mostly related to theft and crimes of dishonesty. So depending on this one, it is most likely that the individual, if they are convicted of this, are required to report that crime or conviction or guilty plea of that. So it does not matter if it is a felony or a misdemeanor. It is a conviction or a guilty plea. The only issue, I would not recommend assessing a civil penalty and litigation monitoring because litigation monitoring is a consent order, essentially, which means the individual is going to update us of whatever is going on. So if we are going to assess a civil penalty for the individual failing to respond to us, I would recommend probably doing that on the back end of whatever is happening. I'm not sure exactly how that would work. They're kind of two different pieces that are working. I'm not sure even how we would add that in core. But so that's kind of what is going on here. So
we've had instances in the past where licensees haven't informed us as they're required to.
Yes.
And staff was able to discover that instance and revoke automatically that license.
Yes.
With no further action from us.
Yes, so, and if they do recommend, let us know of the guilty plea at that point, then, it would proceed to like a formal hearing, and we would make a determination on their license as to whether that individual keeps their license or not. And it would appear on the legal report, and then you would make a determination if that person keeps their license, and then go from there.
All right, so the recommendation is
Sorry.
Question.
civil penalty. Go ahead.
So let me make sure I understand this. The complainant is a title company, and they're complaining that a agent changed the wiring instructions from going to the broker instead of going. I mean, it was supposed to go to the broker, but it went to the agent instead. Is that right? The complainant. It says the complainant is an officer at a Tennessee title company.
Yeah, they're like related to like their old firm, and like they were all related. So it was like people he was previously employed with and had involvement with, and then spoke. It was a very complicated thing, like on their end.
So the complainant is a Tennessee title company as well as a broker or an affiliate.
They work with them, so like they're like in.
Sounds like a business relationship between a real estate firm and a title company.
They're like a business.
I'm trying to figure out who does the complainant work for?
The complainant in this situation is his old firm, and like essentially like they're working together. It's like two separate people like that came together as complainants. So hold on, give me 1 minute, and I'll. Hold on, give me 1 minute. I can pull it up and tell you exactly what it is.
Because it looks like that. I mean, the way I read it was the complainant was a title company, and they wired the money incorrectly, and so after the fact, they're complaining that they made a mistake, but maybe that's incorrect. So, did they catch the error? Or I mean,
they didn't catch the error until way later.
The council's asking us to assign a civil penalty for failure to respond, not the disposition of the case, and it seems to be complexity.
Okay.
So it is a fact. It seems like that council did not receive a response from the respondent about the allegations, and their recommendation is to assign a civil penalty for not responding. The other part is how the money was handled and what the disposition of that is. And Ms. Matlock is suggesting that we handle the non-response issue first, and then maybe there's something else we can do outside of that.
Got it. Okay.
There's no motion presently, no.
And I'll make a motion to accept council's recommendations.
Just for clarification, I'm so sorry, I had to go through my notes again. It was the chief legal officer of a title company, and it was a parent company of a different title. Like essentially, it's an umbrella. It's like the parent company of a different title company. Yeah, sorry, I apologize. Yes, that's what my notes reflect. Yes.
So the lack of response then was, it says you got a few emails
between,
and that's it.
It was between members of the title company essentially questioning where the check had gone, and everyone seemed to agree that the respondent was the last person to have the check, that it was given to them, and they're under the impression that they changed it to their personal account. They changed the address completely so that it went to them instead of the brokerage it was supposed to go to.
Right, but the respondent has not communicated with it.
But did the respondent respond in any way?
I didn't get any documentation with that.
So we do have a motion that's been motioned by Commissioner Torp to accept council recommendation, seconded by Commissioner Tucker. Any further discussion, questions, friendly amendments, substitutes?
Should we amend to put that in litigation monitoring if something were to come to that?
What Anna was saying is we would find out.
Okay.
If we didn't find out, they would have to tell us, and if not, then they probably.
Yeah.
Well, we found out earlier if we didn't want to do it.
Was it not your recommendation, Anna, that we don't revote?
I said if we do put it in the, if what. My recommendation would be if either one or the other, essentially, to assess the civil penalty or to put it in litigation monitoring right now and then assess the civil penalty on the back end. Because I don't know how you would do the two together. But the issue is with the litigation monitoring is that we have to contact the respondent in order to kind of put it in litigation monitoring. But like we can do one or the other. So it is really up to you what we would do. Litigation monitoring, essentially, just to give you a quick reminder, is the legal counsel entering an agreement with the respondent, letting them know that they are telling us they're going to give us an update on what is going on with their case. And so that is the agreement until the disposition at the end of whatever is going on here. And if they don't tell us that, they're in violation of the litigation monitoring agreement. So, not necessarily. The license would not be revoked. We can't do automatic revocation like that. So there would be possibly suspension, maybe, but their license is already currently suspended for E&O right now.
So what if they get the $1,000 civil penalty
Yes,
and they do respond? So then you say respond.
right.
Do they still have to pay that civil
Yes.
penalty? If they respond, is it going to be a represent with new information? Like the civil penalty, like once we.
So if we give out the civil penalty with consent order, then complaint is closed. And then what we would do at that point is, it would be on the respondent at that point, on them to let us know if they have violated, if they have pled guilty or been convicted of the underlying criminal offense.
There is a second. There is a motion on the floor. You can.
Yeah.
Yeah, so are we in communication with the broker, or do we need to open
We don't have a complaint against the broker. We wouldn't enter something with the broker. But I don't think that would necessarily be appropriate. I mean, we could communicate with them, but ultimately it's up to their respondent, like their affiliate to.
So is there litigation to monitor? Because I don't think is there a criminal complaint?
Well, there's it would be the underlying criminal, convicted criminal proceeding. That's the word.
So there is one?
Yeah, so there's criminal proceedings. That's what we would be monitoring. So if you want to, that's probably a good idea. Let's just put in litigation monitoring.
I support that because it's a huge number being paid directly to an affiliate.
Well, I mean, I think the non-response is what is that question here. They didn't respond to
A serious accusation.
They didn't respond to the complaint. We don't know the disposition of the criminal court case yet. I was about to say, for the response, I think it's clear that their civil penalty is warranted, and if they are convicted, their obligation is to let us know what the disposition of in the event of a guilty verdict or a plea. So I don't know if they would necessarily agree to keep us informed with litigation monitoring. And I kind of like the fact that the stick that is out there, if they do not inform the commission, is that their license is automatically revoked, rather than preempting it with a litigation monitoring.
Okay, call the question.
Question has been called to accept council's recommendation that we assess a civil penalty of $1,000 for non-response.
Yep.
All those in favor?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations. Now, there's one final piece on the agenda that I think is still pending, is the election of the chair and vice chair.
I thought we talked about it.
Did we do?
The table, but I thought we said
No, we need to talk about the panel for,
Yeah, Mr. Chairman, I think we have a couple items remaining. We have the officer
So-
selection. We've handled the appointment of the executive director.
And we did the TREC meeting dates earlier.
We have the TREC meeting dates, and I think it somehow got left off of here, but I thought at one point we had a, I thought that was on listed on here. Okay.
It's that meeting in September that we didn't have to have three. You know what I'm talking about?
Yes, ma'am. Yep.
that's with the women and the brokers.
Yeah.
So if the,
You know what day it is?
yes, ma'am. That's September 20th at 10 a.m. and that's at the Cool Springs Marriott in Franklin. And so they had asked if we could have 3 commission members present. I think the name of that, I think it's the annual. It's their annual broker summit.
We'll be on panel.
Their legal counsel, I think, will moderate.
I'm glad to do that.
Okay, Commissioner Ferris in Middle Tennessee. Thank you. Any other volunteers? Okay, so Commissioner Smith, Commissioner Tucker, I think that's 3. If there's others in attendance, we can share that with them or anyone else that would like to participate. But we've at least got 3. If y'all would like to make a motion, but I think we've got volunteers, which is fine. And just a friendly reminder, I know y'all are veterans at this point and know the drill, but just a friendly reminder that when you're speaking in that capacity, you're speaking on your individual or as an individual on that basis and not holding out an official perspective or viewpoint of the commission. Just friendly reminder on that. Thank you.
Okay. One item I wanted to bring up, and it's not on the agenda, but typically when a commissioner departs at the end of their term, we have nominated that individual for the Bill Toon Award. It's not on the agenda, but I would open the floor for such a nomination to recognize Commissioner Franks for her service on this board and to wish her well in her future. Is there anybody that would like to make that nomination?
I'll make that nomination.
Is there a second? I have a nomination by Commissioner Gwynn, seconded by Commissioner Ferris to award the Bill Toon Award to Commissioner Franks, our former chairman. All those in favor say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. I'm sure staff will. Second was Commissioner Ferris. And I think staff typically notifies TR about that recommendation from us. Okay. All right.
Mr. Chairman, sorry if I may weigh back in, and if the commission would choose to punt this to a future date, I totally understand. So I think in the executive director's report, I had intended to bring up the agreed citation schedule. If the commission would entertain a brief discussion of that, I had some remarks I wanted to make. Caitlin and I had discussed the need for a discussion at this on that topic at a future commission meeting. So I know we've gone a little bit long. If y'all rather save that for a future day, I understand. I think it would be fairly quick, so I'd just like to.
That's optimistic, but do we want to hear it now? All right, let's hear it now and get it over with, so we're not here late in September.
Yes, sir. So I think this will be brief. So just as a friendly reminder, the executive director does have delegated authority from the commission for an agreed citation schedule as it relates to advertising. And so on the first penalty, that's a $500, or on the first offense, that's a $500 civil penalty. On the second offense, the commission has authorized a $1,000 civil penalty, and then on the third offense, the commission has authorized a reference to legal. Now, of course, if the respondent does not agree to the agreed citation, it goes in the legal report like normal, and y'all would see that in the consent agenda therefore you would have the ability to pull that case, et cetera. So that's just sort of the general process. And this works well because, hey, there's quite a few of those, and so it sort of streamlines the work that you all have to do. What I wanted to put before the commission, and again, Caitlin and I had this conversation prior to her departure as a discussion item, I think it's just worth deliberating, is from time to time we receive phone calls or brokers, other folks maybe who genuinely did not understand the rule, or that in other aspects it might be our position to issue a warning first, rather than just going to that $500 civil penalty on the first offense. And so wanted to throw that out there for discussion. This is not a rule change. That is authority that is delegated from the commission to the executive director. And so I simply wanted to point that out as a potential discussion item, that on the first offense, would it be appropriate to move to a warning first before we're automatically going to a penalty? And then kind of the final point there is, because that authority is delegated in a very specific manner from the commission, the executive director, myself, can't then say, oh, this looks appropriate for a warning, right? You all are making that determination that this is the schedule, this is the specific schedule based on the number of offenses. So throw that out there for conversation and y'all's consideration.
So my initial reaction, I'll take the floor first. My initial reaction is letter of warning. I think, somebody might take advantage of that and say, oh, if I goof, I just get a letter and I don't have to worry about it. It's not going to cost me any money. So would it be possible to instead, with a letter of warning, make them take a class on advertising and say, all right, well, you made a mistake, take an advertising class and it doesn't count towards your CV. I think that's 3 hours. I want them to feel a little bit of pain. I want a stick there.
There's not like a specific advertising class, so it'd be the core class that they would
Well, that just makes me feel better. I think there needs to be a sting there on our first offense, because the advertising guidelines are there, so we don't defraud the consumer. And I don't want anybody to say, oh, my first offense, it's nothing. And I think that a letter of warning is kind of, they'll file it, but I don't see them. I just want to disrupt the possibility of somebody saying, cost of doing business, letter of warning, move along. I want that. I am not going to do that because I don't want to sit through a 6-hour core class. That's what I want. I want some kind of deterrence. That's my reaction anyway, but commissioners may feel different.
Maybe you give them the option, the class or the 500, because if I'm a new agent and I made a mistake in 30 days after I started practicing, I just had the class.
Right. I don't know that they've gone to their broker.
It's something, yeah.
They should have known. I need to go to my broker so my advertising can be approved. That's what they should have known from that class.
The other question is, do we have any stats to know how often does this occur? How many fines she was giving out a month, or any data?
That's a great question. I don't have that right in front of me. And again, so I don't want to push the commission to make a hasty decision. Caitlin and I had some conversations about this. I felt that it should be revisited and wanted to bring that up, so we can certainly pull that if you think it would be helpful in making a decision. I certainly agree with the chairman's comments that we don't want people to brush over it either, but also trying to strike that balance between should we really be punitive when someone simply misunderstood, or that doesn't mean that we should gloss over it, but typically it falls in two groups, right? People who are repeat offenders and people who simply didn't know and need to be educated. And so I wanted to bring that up for the commission's consideration.
Sounds like we're going to have to talk about this in September instead.
Yes, sir. Sounds great.
So is the commission interested in knowing the statistics and figuring out how prevalent these first offenses are? So we would want staff to have those metrics for us. Maybe if you could send it with Aaron's packet, so we have time to look at it ahead of this September meeting and digest it.
Sounds great. Happy to follow up on that.
Can we talk about our room arrangements now? Is that appropriate?
Sure.
Okay. Aaron, I think some of us are happy where we stayed last night. So I know we're wishy-washy, but is everybody okay with where we stayed last night? If we stay there from now on, or at least for several months?
It's available, right? That's the problem.
That's the issue. That particular hotel, if you remember, you're gonna be there next month.
Right.
We're traveling in October, so November is not ready to do the next courtyard, but December you're back there. So it's not always available for that rate. But going forward in January, I can archive. So this position will only be at the courtyard where you would have to make your own reservation. So that
January?
is going to be, so you will not be back at the
So I understand you. If the state is going to make the reservations, we're only at the courtyard. And if we don't want to stay at the courtyard, we make our own hotel room. Okay.
And then when you get reimbursed,
Do
or
you-
you make your own and we pay for it.
still bring me your invoices.
And reimburse the state rate,
Yes, state rate.
so you may not be made whole,
So why is the courtyard to go to after January?
because they offer the state rate for us
The
now.
only one that offers state rate.
But the AC, because of where it's located, we could not get a film contact like we were able to get at Franklin, so to actually take us on, because they have so many projects going on, and that's just the locations that there are. So they could concrete negotiations that us for our contract, to kind of work with us month to month, so that it's as a need or as available.
Is there another Marriott closer to the AC Hotel that would work with the state?
There are several within the vicinity that carry the Marriott banner. I can look just to see if possibly gives this one final option outside of the courtyard for that area. And I'll have that for you next.
You are good. Thank you.
All right, any other,
So we still have the.
we still have the chair and vice chair.
Can I just make a comment real quick?
Sure.
I know y'all want to get this done, but I feel like the vote could or would be different if we had a guarantee that Jeff would continue. So I almost feel like it's a disservice to have a vote if we don't know, if that makes sense. Like, I'm good with whatever, but we've gone through this meeting. You're the vice chair, which means you're operating as the chair.
Mhm.
So you're currently, by default, the chair. So, I don't know. I'm comfortable waiting until the next meeting because I feel like it's hard to make the decision when we don't have all the information in front of us. That's just me. If anybody else has a comment, I'm happy to hear it.
I'm happy to make a motion that my original motion failed. So I'm happy to make a motion to defer to September.
Second.
So the motion is to defer the chair, vice chair elections until the meeting in September by Mr. Glenn, seconded by Ms. Torbett. Any further discussion or questions? Hearing none, all those in favor? Joe? Want the microphone? No, it's open for discussion.
And I said it earlier, you don't know who's gonna be here, what's gonna come up, how many people, I don't know if you're gonna.
I think the difference
One more vote.
we would know is just how family years.
Well, we hopefully would know by then, but we don't know.
Yeah, if I could just clarify, and again, this is y'all's decision, y'all deliberate, take the time that you need, but we are not in a position to know when the governor's office will make that decision. It could be tomorrow, it could be September, it could be December. I'm hopeful that it won't take that long, but, we're simply not
You've been
privy.
checking your email, Alex? Do you know right now?
We're simply not privy, to that process. And I just don't want there to be a perception that if we wait, that the decision, or that there will be new information in September. That might be the case, but it also might not be the case.
Yeah, and I was just going to have a remark that thank you for nominating me, Joe. I'm glad to serve as chairman. I'm glad to serve as vice chairman. I would just say, while it's known by all that Jeff's term was over June 30th, but we all are serving at the pleasure of the governor and the governor's office. So they might review this meeting and call me tomorrow and say, thank you for your service. So we're all at the pleasure of the governor, and rightly so. The governor's office is focused on the special session that is of key importance at the state right now. And so we don't know that what it'll be, when we will hear or whatever. So, in the interest of, it's allowed me some time to think here, but there's a story about harmony, and Leonard Bernstein was asked about harmony and or what's the hardest, most difficult thing to find in a orchestra, and what's the hardest thing about putting together a really good musical piece. And he said that the hardest thing to find is someone who will play second fiddle enthusiastically. So in the interest of harmony, I'm glad to be vice chair if we want to move forward. I'm glad to be chairman if we want to move forward, or move into September, either way. So we're a strong body. We work well together, owing to all the great help that the state provides with the council and assistant commissioner, new executive director, everybody at TREC, Ross, Rihanna. So thank you all. But again, just a reminder, we're all at the pleasure of the governor. So.
Can I ask a question of our?
Sure.
So my question is, I guess Jeff is currently the vice chair.
Mm-hmm.
He would continue to operate as vice chair until we have a chair. So he's basically the chair until we have a chair. Yes?
He's the vice chair.
So he's the vice chair
presiding
as the chair. So I feel very comfortable with that, waiting until we find out if we get 5 more years with him, because I don't.
Well,
Okay.
We have an active motion. I don't know.
Call a question.
I don't know if it's been seconded.
Yeah.
Has that motion been seconded?
It has.
Okay, so I think we need to vote on the motion that's been seconded.
Motion is to defer. So that I understand the motion. You ready to vote? I don't think we need to do that. If it's questionable about the outcome, or we'll just do a voice vote. All those in favor of the motion to defer the election of the chair, vice chair until the September meeting, say aye.
Aye.
Any opposed? All right.
I think we need.
You got to resolve this first.
I think we need to do a roll call vote to make sure we're.
Anna, please call the roll.
Commissioner Ferris.
Yes.
Commissioner Glenn.
Yes.
Commissioner Moffitt.
Yes.
Commissioner Smith.
No.
Commissioner Torvik.
Yes.
Commissioner Tucker.
Yes.
Commissioner Beckley.
No.
Commissioner Diaz.
No.
4-4.
Roll for it.
So that motion failed.
That motion failed.
Make a motion. Now, Joe, what you got? Oh, I have a question. Let's just say that if, yes, and you're able to fight.
It's a new vote.
I know, I just asked the question. And in that scenario, win, and then, if we were just having you election, you know, and you know. So that's the thing.
And it's correct. You just have a new vote.
Make a motion.
I make a motion that we vote by roll call. And either we tie or somebody wins or we go home.
So to clarify, you're saying vote on the position of chairman. You're not,
Chairman,
the previous motion was to defer until September.
which is tied.
Which is tied.
I make
That
a new motion
fails.
to vote by roll call.
By roll call.
For chairman.
Okay, so we have a motion, do we have a second? We have a motion, we have a second.
What's the motion?
Motion is to vote for chairman by roll call at this meeting.
But not on who the chairman is.
Yes.
Yes, for chairman, roll call vote, no secret ballot.
So is
Got it. All right.
it the same panel of nominees?
No, we need new motions, new whatever nominees.
So we need new nominations for chairman is open. Does anybody wish to make a nomination for chair?
Don't we vote on his motion?
We didn't.
It was seconded, but a motion without objection, I don't know.
True. My mistake, I overstepped. Motion on the table, made by Commissioner Begley, seconded by Commissioner Tucker, is to have a new roll call vote for chair and possibly vice chair, depending on the result. Now, is there any other further questions or discussions about the motion? All those in favor, please vote aye.
Aye.
Any opposed?
No.
It appears that the motion carries 5-3.
So that's Commissioner Corbett, Commissioner Moffett, and Commissioner Diaz.
Yes.
Voted no?
Yes.
Okay, so need your nominations.
The floor is now open for nominations to be chair of the Tennessee Real Estate Commission. Are there any nominations? Is there a second? Final chance. We have a second by Commissioner Smith to nominate DJ Ferris. Any further nominations?
Nominate Jeff Diaz.
I have a nomination to nominate the vice chair, Jeff Diaz.
No, not vice chair.
I'm sorry, the current vice chair, Jeff Diaz, for chairman, seconded by Mr. Moffett. Are there any further nominations? Who's going to know? Oh. All right, so any further nominations? Hearing none. Floor is open for discussion. Commissioner Ferris.
I was just saying, just the whole harmony of the board here. And again, as I said earlier, I'm glad to serve as chairman, I'm glad to serve as vice chairman. Jeff qualifies to be here as well. I'm supportive as vice chairman going forward. However you all vote. And I can't not vote for myself if that's my vote. So a vote for me doesn't mean to be a vote against Jeff, but I'm just saying for us all and our camaraderie here, let's just make this easy. Jeff is reappointed. He's, again, we think 5 years. Again, it's a pleasure of the government. We don't need to get hooked up on 5 years. So that's just some thoughts here.
All right, so there's a roll call vote, so do each of us need to speak the person that we are voting for on a roll call? Okay. Is there any other further questions or comments? Hearing none, Ms. Matlock, you can call the roll.
Commissioner Ferris.
For Commissioner Chris.
Who are you voting for? When I Say your name, state who you're voting for. Commissioner Gwen.
Yes.
Commissioner Moffett.
Yes.
Commissioner Smith. Commissioner Torbett. Commissioner Tucker. Commissioner Beckley. Commissioner Diaz.
Myself.
The motion fails. We have a vote.
And that's why it's failing.
Here, I'll make a new motion. I move for Jeff to be chairman.
Motion to nominate Jeff Diaz for chairman. Is there a second?
Second.
Any further nominees? Hearing none. Seems the resolution is to be for Jeff Diaz to be chair by acclamation, since it's unopposed. Or do we need a vote?
Yeah, we're going to vote.
Okay. Could be by voice. All those in favor in the motion to make Jeff Diaz chairman of the Tennessee Real Estate Commission, vote by saying aye.
Aye.
Any opposed? Hearing none, that motion passes unanimously. Now, chair is open for motions.
We're all jumping in here. We want a motion.
Is there a second? I have a motion by Commissioner Smith to nominate Commissioner Ferris for vice chair, seconded by Commissioner Tucker. Any further nominations? Hearing none, let's vote. All those in favor of the motion say aye. Aye. All those opposed? Hearing none, that motion carries unanimously. And at long last, it appears that our business for voting for chair and vice chair is complete. Sir.
Yes, sir. Mr. Chairman, if I could make a brief comment, I know we're all ready to adjourn. So I just want to say a meeting of new things, new chairman, new executive director, a new commissioner, which we've discussed. So I just want to say thank you all for bearing with us through all this. I know it's been an eventful meeting in a new space as well. So thank you for taking the time to be engaged enough to deliberate. That's how this should work at times. We don't have to agree on everything. We're not in an echo chamber. And so I appreciate each of your time, appreciate your service, and all that you do for Tennessee. Thank you.
Thank you, sir.
I think we need a final motion.
Yeah.
Let's do dirt.
Second.
That's travel.
Have a good trip home, everybody.
I think I would feel better giving them back to them.